So thank you for joining me for another deep dive. And my name's Eric Lee. If you're watching this video and you don't know who I am, then that's who I am. I'm principal broker for equity real estate in Utah. And today's topic for a deep dive was chosen because, like most of my topics, I see an agent have trouble with a form, and I think, you know what, this comes up pretty frequently. And this one especially comes up all the time where agents don't understand how to use the form. And part of that is due to this form changing over the years. So it's not necessarily a new agent that misunderstands it. A lot of times it's an older agent that has a lot of experience, but the form has changed and they haven't changed with it. So a quick example of this, that's one of my favorite examples. Some of you that have been around for a long, long time will remember what section 10.2 of the REPC used to say. Does anybody remember that? What section 10.2 of the REPC used to be? I'll share my screen. And I've got the REPC as one of the things that we're going to talk about. Does anybody offhand that's been around for a while remember 10.2? No? Okay, 10.2 was the one that was the exact opposite of this. And so we saw over and over in offers made that 10.2 does not apply because it was saying that there was some kind of a warranty on the property or something like that. I don't remember exactly what the language was, but it was something about the warranty on the property. And so it was almost standard language in every offer that section 10.2 does not apply. Every property was sold as is. And because we were adding that every single time, we changed the purchase contract. And now 10.2 says that in reference to the physical condition, the buyer is purchasing the property in its as-is condition without express or implied warranties of any kind. And so agents that didn't stay on top of their forms, good agents that have been around for a long time, but this form changed, and they kept writing in section 10.2 does not apply. And they were effectively undoing the exact thing that they thought they were doing, right? What they thought they were doing was saying, hey, it's sold as is. And now in every form that they wrote, they were effectively doing just the opposite of it, because the attorneys, when they said, hey, this is a problem that keeps coming up all the time, let's fix the one section that has the problem. And it happened to be the exact one that when they rewrote it, now it created a new problem for all the agents that hadn't paid attention. Well, that's what we're running into today. And that's what I want to cover with the subject to sell of buyer's property. Okay. So let's jump into that with our deep dive. And again, if you've never joined me for a deep dive before, we pick one form, we go into detail on it. If you guys have questions, you're welcome to ask your questions. But we go into a lot of detail, which is something that is almost never done, but it gives you a deeper appreciation. One that I get to see from my viewpoint as a principal broker for 2,400 agents, I get to see lots of problems. Okay, ones that you guys hope in your entire career you won't get to see. So an average month for me would be an average 2,400 months for you in this business as far as problems that potentially come to my attention. And with that comes some knowledge, and I hope to pass some of that along to you so that you don't have to learn through the school of hard knocks. Just adjust my screen a little bit. And because I don't see all of you very well when I'm sharing my screen, if you have questions, comments, please click the little button to raise your hand. It's on your chat panel, or you can just unmute yourself and ask a question that way. So first of all, we're looking at the subject sell of buyer's property addendum. Now, before we get into this, I'm going to jump down to the real estate purchase contract because I get asked this question. And this is where it's referenced. It's in section 2.2. The buyer's ability to purchase the property to obtain the loan referenced in section 2.1 above, which is where it talks about the money, right? And or any portion of the cash referenced in section 2.1e above. So if they have to bring a little bit of cash to closing, if they're getting any of that from the sale of other real estate, then you must check is. Okay. So if you're under contract on a property and it's set to close in 2 weeks, and you need to have that money, in order to close on this home, but you're under contract and it's going to close in 2 weeks, you pretty much already have the money. Do you still need to check is? I'm going to wait for an answer here. Yes, Monica says yes, and she is correct. Okay. So even though you're under contract, it's pretty much a done deal. I did have a question asked on this last week, and they said, hey, we're going to be, it was Friday when they called with the question. They said, we're going to be funded and recorded by Monday. Do we need to check is? And I said, you know what? By the time this goes under contract, you're pretty much going to be done. If for some reason that sale doesn't go through on Monday, then you can add this as an addendum later on. You can correct this. But that's the one case where, you know, like we're going to have it sold in 2 days. So by the time we negotiate back and forth and have it under contract, we'll have the home sold. Then maybe you could do is not. Otherwise, you're considered not negotiating in good faith, right? It's a legal term that says, hey, you basically lied when you made the contract, and so everything could be voided. And we definitely don't want that for our clients. So even though making the sell of the buyer's property, making the subject to sell of another property weakens your offer, we have to be truthful. Okay. And if we need that property to sell, now there are instances where, let's say that we have the cash available, you know, we can cash out a retirement account or something like that, but we would prefer not to, but we could, right? We could go all cash, but we would prefer not to. We would prefer to sell this other property. In that case, you could say is not, as long as you're willing to do what you prefer not to, right? You could cash out that retirement. You could do whatever you need to do to move money around and make that cash sale happen. So as long as you're willing to actually do that, then it's fine to check is not. Otherwise, if you're not willing to do that, you could, but you're not willing to, then again, negotiating in good faith says that, yeah, we do need to sell this other property before we're willing to close on this. So that's where the sell of buyer's property comes into play. We can't lie on that. We can't cheat on that. We need to negotiate in good faith. So now let's jump to the subject to sell a buyer's property addendum. This is the one that you must use. It's been prepared for you and it's all ready to go and it's written very well. So we've got our standard references up here, you know, referencing the date, the buyer, the seller, and the property, and the subject to sell conditions. So we put in the location of the property that they're trying to sell. Now, as a side note on this, if you are the listing agent, what's one of the things that you would want to check? Anybody? You're a listing agent, buyer brings you an offer subject to sell. Here's the property. They give you the address.
You'll check the MLS and dig as deeply as you can.
Yeah. You want to look up that property. Is it priced right? Is it in an area that's moving? You know, we want to get details so that we can better advise our sellers. Okay. So yeah, we do want to see the details of it. So the property address goes right here. Now let's read through this. And this is where the mistakes are made. The buyer's right to cancel before the due diligence or finance and appraisal deadline, whichever is later. Why would they put whichever is later? Isn't the finance and appraisal deadline always later? Why wouldn't they just say the finance and appraisal deadline? Anybody?
Maybe it's cash.
Maybe it's cash. There is no finance and appraisal deadline because when we went to the purchase contract, we said it's not subject to that. And so the only thing we have is a due diligence deadline. If it's cash, right? Maybe they're waiving their due diligence, but they do have a finance and appraisal deadline. Anyways, it's whichever is later, and it's only those two. So if they waived both deadlines, this is a tough form to use. They pretty much need to have one of those deadlines in place. Let's say that it's a cash buyer. We have no finance and appraisal deadline, right? So we just have a due diligence deadline. Now we got to read this language. Buyer may cancel in their sole discretion if the buyer has not closed on the sale of buyer's property by providing written notice to the seller no later than the due diligence deadline referenced in section 24B or the finance and appraisal deadline referenced in section 24C. And again, if finance and appraisal hasn't been selected because it's cash, then we don't have a deadline in 24C. All we have is a due diligence deadline, whichever is later, whereupon the earnest money deposits shall be released to the buyer without further written authorization from the seller. So the problem that we get now is we jump down to our purchase contract and we come down to the last page where we have our deadlines. And we've got our due diligence deadline that's, we'll just say today. And got our finance and appraisal deadline on the 22nd. In this case, let's change our scenario up a little bit. And say that there is finance and appraisal rather than it's all cash, right? It doesn't matter for the illustration that I want to make right now. But here's the problem that we get is agents, because it's a subject to sell and we don't know when that property is going to sell, they come in here and instead of doing a date, I'm not sure if I can even type into this field from here. Yeah, I can. Within 3 weeks of sale of buyer's property. What happens when I do that? Right? And instead of putting a date in here, say
That could
within.
extend it. That could extend it almost indefinitely.
Yeah. So the problem with writing it like this, and by the way, the old language, the reason I started the training the way that I did is the old language had us be able to write that out. Say, oh, hey, we don't know when it's going to sell. So within a couple of weeks of the sell, then these deadlines come into play, right? But now we've got a circular argument. So I go back to the subject to sell addendum, and it says that if the buyer hasn't closed on the sale of the buyer's property by providing written notice no later than the due diligence deadline, and I go here to my purchase contract, and I see that my due diligence deadline isn't a fixed deadline. It's within 2 weeks of the sale of the property, then I've created a circular argument. And this is what I saw last week. And it was between two equity agents from different branches. So it was limited agency. And they emailed me and they said, which one of us is right? And I said, without any tact at all, because sometimes there is no soft landing, right? I said, you're both wrong. Neither one of you should have allowed the contract to be written this way. The circular argument, all it does is there is no solid answer. And without a solid answer, it creates confusion, it creates frustration, which creates lawsuits. And if it goes to a lawsuit, both of you look very poorly in front of your clients, right? So neither one of us is right. So we can't do this. Cannot write the contract this way because it makes a circular argument. I have to use fixed deadline. So now that I've got a fixed deadline in here, this reads correctly. So if the buyer in their sole discretion, if they haven't closed on the sale of their property no later than that deadline. So again, if we've got cash, if we've got a cash buyer, let's jump back to our purchase contract. How do I need to fill this out? Scroll down to those deadlines again. If we've got a cash buyer, I don't have a deadline here, right? That's not applicable. So my due diligence deadline, how do I fill this out? Due diligence, typically we're done in 2 weeks, right? We can get in, get our inspections, we're done in 2 weeks. What do I need to do now? This is the only way I have to protect my client. I have to have a firm date in here. That means I've got to push this date out. So we're going to go out, whatever typical days on market are, we need to make sure that we've got our property priced aggressively. But even though I only need about 2 weeks for due diligence, I've got to give myself a couple of months to get my property sold, right? Now, on the other hand, let's say that let's see, Andre Ice Cold 3000. Got a question? Go ahead. You got to unmute yourself. Do we have a question incoming? Maybe you're typing it in. Okay, I'll finish my thought if you're typing. Otherwise, you need to unmute yourself so that we can hear you. So here's the thought, right? If it's cash, this is my only option. I have to push my due diligence deadline out so that I actually have protection with the subject to sell a buyer's property addendum, right? Now, most of the time it's not cash. Maybe it is. Once they sell that home, it would be a cash offer. And so this is what I have to do. But in a lot of cases, we still need financing. So we've got our finance deadline that's out a little bit further. In this case, since I have a finance deadline protecting me, I want to get my due diligence done quickly. So I'm going to go back to, it's actually July right now. Sorry, I needed to do, this one didn't go out far. Go out to September. Oh boy. Come on. September 16th, we'll do that. Okay, there we go. All right, now it looks right. So if I'm writing this offer today, then I can give myself the standard week or 2 weeks for due diligence, and I can get that done quickly. Now that shows the seller that I'm pretty much negotiating in good faith. I can get the things done quickly that I need to get done, but I have to push one of the deadlines out in order to protect myself in accordance with the subject to sell a buyer's property addendum. All right. So I've protected myself by this deadline correctly, understanding that whichever is later means that if it's cash, I've only got the due diligence deadline to protect me and I have to push it out. If I've got financing and appraisal, then I need to still, in my opinion, it shows a buyer that's being genuine when they get in, they get their inspections done quickly. Some buyers might say, hey, why should I go in and pay for the inspection and do all of that stuff if I don't know if I've got my other property sold yet? Then why do I want to invest that money? And my response as a seller would be, well, I don't want to keep the house off the market for a couple of months if you go in and do an inspection or find issues with it, right? So that's kind of the give and take. Like, you show me that you're actually motivated. We clear inspections in the couple of weeks and I keep the property off market for you because, we've got this addendum in place. But you need to go ahead and get those inspections done. Do the work that you can do right up front. Now, if they cancel prior to these deadlines, then the remedy is very clear. The earnest money deposit is released back to the buyer. They've done their part. They get their earnest money back. Now, if we go down to B, they have a right to cancel after the due diligence or finance and appraisal deadline. Why would somebody want to cancel after? And why does this give them the right to do that? Well, let's read the language first. If the buyer doesn't cancel the REPSI by the due diligence or finance and appraisal deadline, whichever is later, this section up here, they didn't do that, and they haven't closed on the sale of their property, then they can still cancel the purchase contract on or prior to the settlement deadline by providing written notice to the seller, whereupon the earnest money deposit shall be released to the seller. So before it was released to the buyer, now it's released to the seller. And seller agrees to accept as their exclusive remedy the earnest money as their liquidated damages. Now, the reason this is important is we're basically saying, if we go to the purchase contract, we're basically saying that, hey, if we cancel on or just before the settlement deadline, we missed our other deadlines, but we canceled prior to the settlement deadline arriving, then we have not defaulted by the language written in the contract. It is not a default. All right. So we failed to sell our home. We failed to cancel by the due diligence or finance and appraisal deadline, whichever is later, but that does not constitute a default, because default means if the buyer defaults, the seller can choose one of the three following remedies, and they've got three different things they can choose. Earnest money is just one of them. It's the easiest one. It's the most common one. But they could maintain the earnest money deposit in trust and sue the buyer to enforce the REPC. That's a long shot most of the time. Or one I have seen happen is return the earnest money deposit and pursue other remedies available at law, which is usually actual damages. Okay. Hey, we'll give you your $5,000 earnest money back because at this point we've incurred $15,000 in other damages. We have to cancel our contract. That's an expense. We've already moved out because you canceled the day of closing. And so that's an expense for us because we've paid our moving expenses. Now we have to move back. And a good attorney can help come up with lots of different expenses, right? Like you write down everything to come up with the biggest number possible. And it may be a lot more than that $5,000 earnest money was. So we go back to our subject seller buyer's property addendum and the right to cancel after the due diligence or finance and appraisal, but prior to the settlement deadline. Now that's on or prior to the settlement. So it could be the day of. That deadline's 5 p.m. on whichever date. They could cancel by 4 p.m. And what they've said is, hey, we canceled prior to the settlement deadline or on that deadline. And therefore, the only remedy that you have available, rather than suing us for anything else, the only remedy you have available is getting our earnest money, right? We know we're losing that. We're giving that up without a fight. But in exchange, you can't try to sue us for anything else beyond that. All right. So that's that section. Now, buyer's property. Andre, I saw you unmute yourself. Did you still have a question?
Yes, so my kids are tinkering with my computer, so that's why I don't know how to unmute myself. But I just had a question back on the deadline for you want to extend this out. If you're representing the buyer, you're going to want to extend that out 2 months. But every single offer I've ever written where I try to give my client the most time, the listing agent always kicks back and says, hey, we don't want you to take all that time to do your due diligence. And so maybe my question is, how do you make that argument that they need 2 months of due diligence time?
Now, again, the only way they would need 2 months for due diligence is if it's a cash offer. Like, hey, once we sell our property, you don't have any concerns about meeting the appraisal requirements. There's no lender, there's no underwriting. Like that part's going to be a breeze. But in order for me to use this addendum to protect my client, the buyer, the only thing I have left is this due diligence deadline. And yes, I know it doesn't take me 2 weeks to do due diligence. In fact, I'll go and we'll get the inspection done in the first couple of weeks. So, we're showing good faith. We want to show you that we're working diligently towards buying this house. We're making every effort that we can. We want to stay in your good graces. But this deadline is the only thing that protects my client, and we can't proceed without this, right? Now, of course, that leads us to our next thing, and I'm going to finish this form really quickly, and I'll lead us to how the seller counters this argument of ours in a way to protect themselves, right? But let's finish this form really quick. So the buyer's property is or is not currently listed on the MLS for sale through a real estate brokerage. In the event the buyer's property is not currently listed, the buyer agrees that it will be listed within 7 days of acceptance, right? Now that there is not a box. You notice there is not a box that says will not, will be a for sale by owner or anything like that. It will be listed with an agent. Now, why is that? Because you'd have to be insane to do anything else, right? We all understand that. We should understand that. It's okay that a seller doesn't understand it. It's okay that a buyer might not understand that. We should understand that. I will not take my house off the market with a subject to sell for somebody that does not know what they're doing. I don't know if they've priced it right. I don't know if they know how to negotiate. There are so many different ways that could fall apart if it's not listed. I will not, and this is the conversation I would have with my sellers, we will not accept an offer from a buyer if they are not going to have their property listed. So that's why this form doesn't have a box to check saying it will or will not be, or we write in it's going to stay a for sale by owner, because I simply wouldn't ever encourage, I can't say I wouldn't allow, because it's not my choice to allow my seller to have a choice or not. It's their choice, but I am going to highly, highly encourage them. Do not even consider this if the home isn't going to be listed with an agent, right?
Eric,
Yes, sir.
I think also it might be good to mention that that includes FSBOs as well, right?
Yeah, that's
Because,
what I'm talking about.
well, I mean, oh, you're talking about everything, right? So, because I was just thinking that the FSBO, the you know, the when you say listed, most people think it's listed with the MLS, and so I don't know. I just thought that might create a little bit of a confusion for somebody who's not wasn't planning on listing theirs on the MLS.
Right. Well, that's why it specifically says, in the event the buyer's property is not currently listed through for sale through a real estate brokerage, it will be on the MLS, and you have to go through a brokerage to have it on the MLS, right?
Yeah, exactly. But if
And the
they
name of the
refuse to,
listing agent is or will be, if it's the buyer's agent is also going to list it, or if they've picked somebody else, whatever, we want to know. It is going to be listed, and we're going to double check that. And if they haven't gotten it up on the MLS within 7 days of acceptance, then they have now breached contract. And we go to that back to that breach section, and we see, okay, the buyer has breached. They haven't gotten their home on the MLS within 7 days. And so we have an option to take their earnest money right now and put it back on the market, right? Now, if the property is, so I raised this question at the very beginning, well, what if my property is already under contract? Do I still have to use this form? The answer is yes, and you have a chance to say we're under contract. And when I send the offer over, I'm in the email, I'm going to say, hey, we've already got the offer under contract. They've already, the buyers of their home have already cleared inspections. We're 1 week away from closing. We're 4 days away from closing. We feel like this is rock solid. And of course, my deadlines would be much shorter up here as well if I'm already under contract and 3 days away from closing. So the agents that are saying, do I really need to use this addendum? Yeah, you do. You just adjust everything, because instead of being 2 months out, you're 5 days out. You're under contract, ready to close in 3 days. You still use this addendum because it's required by negotiating in good faith, but you get to adjust everything and say exactly what's going on, and you're good to go. You've protected everyone. Now, let's look at what the typical counter is. So we go to our option to keep property on market time clause. So now we're the seller. We've received an offer subject to the sale of the buyer's property. And again, it could be months. And they could never sell it. And they send us a notice prior to their finance and appraisal deadline, which is 2 months out or 3 months out, saying, hey, we weren't ever able to sell our home. So we're hereby canceling. And because we're canceling within this deadline, we get our earnest money back. Don, did you have a question? Sorry, I'm trying to keep an eye on the chat and everything as well.
Yeah, I've got two current offers in that are new construction, and the form does not have the conditioned on. We had to do an addendum, and the due diligence deadline is obviously going to be weeks before the houses are completed. Can you address that?
So repeat that again. You're dealing with a new construction?
Two of them, yeah, two different clients.
And
Due
you're representing
diligence,
what? The buyer?
buyers,
Okay, so you're
and
representing the buyer, and they need to sell a property.
one does, one does not, but both of them have due diligence deadlines that are long before the buildings are completed, the houses.
I'd push that deadline out. I
Tried, they
want,
wouldn't let us. They said
uh,
that the only thing they needed for due diligence was for the buyers to look at documentation, warranty, so on and so forth, and prove that.
yeah, then I tell my clients this is highly irregular. Like, we should be able to see a home, and maybe they've got a really good warranty, and so we could consider that, right? So they have an incredible warranty. They're going to warrant their work for a year. We get a chance to do a walkthrough. All of that protection is included in there.
Right.
If I don't have that protection, I'm going to steer my buyer, not steer, that's a bad word to use. I'm going to counsel my buyers that this could be a very bad build to get locked into. Like, we don't have a chance to do due diligence and see it after all the work is done. That's so risky, right? Unless there's some kind of a warranty offered by the builder that offsets that risk. Otherwise, I'm going to go back to the builder. Well, I'm going to talk to my buyer and say, here's all the risk. It's up to you, you know? And if it was something like that, I would document it in writing. I would send them an email in .loop, so it's a permanent record associated with that transaction saying, hey, as per our conversation, this is serious enough that I'm putting it in writing, and we had the discussion that you are very much at risk here. And that risk is somewhat offset by the inspection, or it's wholly offset, or it's whatever, by the builder's guarantee period. But it's your choice whether to move forward or not, right? There is some risk associated with not being able to do your due diligence and do your inspections after the work is all done. But
You know, we went down that road with both clients and both understood that there's going to be home inspection. So still allow them to get out of contract if things aren't kosher. But I'm just curious because it just seemed different to me that the deadline would be before the house was complete.
yeah, that's not ideal. Okay. And just because it's a new home doesn't mean it's built right. Contractors take shortcuts, do weird stuff. So, all right, let's look at the option to keep house on market time clause. So I'm the seller. I just got an offer from a buyer with the subject seller buyer's property. So the first thing that this does is it allows me to continue to offer the property for sale. Now, on the MLS, there is a status called active TC. That's referencing the time clause. Okay, so it still shows active. Your days on market continue to accumulate. Now, if I had just gone under contract, my days on market stop. But if I do active TC, days on market continue to count up. And it does show up active. It shows up on buyer searches. If I had changed it to under contract, then it's not showing up on buyer searches anymore when they're looking for active properties. This one will. It'll show up, and the status it will show up is active TC. Most buyers don't know what that means. Most agents do. That there's a time clause associated with it. And if you're a buyer's agent, that should not necessarily scare you away from this property being a potential property for your buyer, right? So we can continue to offer the property for sale in active TC status and to accept any backup offer. Seller and seller's sole discretion may notify buyer in writing of an accepted backup offer. So this means that maybe I get a backup offer, but I don't like it, right? It's not a very good backup offer. It's another one with maybe it's got a subject to sell a buyer's property addendum. Who knows what it is? Maybe it's just a low price. I don't like it, so I don't have to have that trigger this condition. It's not an automatic trigger no matter what kind of crappy offer I get, right? So in seller's sole discretion, I can see if this offer is good enough that I want it to trigger this, right? So if it does trigger this, then seller is going to provide written notice to buyer. Now, anytime you see this written notice, and it's almost every time, I did find one form where I thought they had created all the notices for it, but there's one where I can't find the notice for it. But a couple of years ago, the UAR the Utah Association of Realtors did a very good job in going through and seeing all this language where notices were mentioned, and we didn't used to have any forms for them. A couple of years ago, all of a sudden we got like 10 new forms with these notices available to us. So if seller does provide written notice, then the buyer shall have whatever, 2-3 days. Typically we do 3 days because what if the written notice was on Friday? Then they have Saturday, Sunday, Monday in which to remove their conditions. It's really hard to do a 1-day notice. You could do 24 hours. You can do whatever you want here. It's all negotiable. Typically, we see 3 days because it accounts for a weekend that might trigger it. But first of all, let's look at the notice, all right? So when we do notices, if I go to, I'm gonna open up a new tab for this. If I go to forms, and I don't know the name of the form, but I know it's a notice, then I can go in here and search for notice, right? Here's all the different forms that have notice in it. So I go back to this and I say, okay, it says that I can notify the buyer in writing of an accepted backup offer. So there should be a notice for that. And right here, buyer, let's see. Seller's notice to buyer of accepted offer. There we go. And it's very simple. Addendum number, whichever one is your option to keep house on market time clause addendum. Okay, so this just says we have a time clause addendum in place. This seller's notice informs buyer that seller has accepted another offer subject to the rights of the buyer provided in the real estate purchase contract. And buyer is advised that upon receipt of this notice, buyer shall remove the applicable conditions from the purchase contract in writing with the agreed upon time, or by failing to respond in writing to this notice, they allow the purchase contract to automatically become canceled, in which instance the earnest money is released to the buyer. Okay, so the seller sends this notice saying, hey, we have a backup offer in place. So let's go back to our option to keep house on market time clause. Option to keep house on market time clause. So we go back to here. We have a right to accept other offers. Maybe we've gotten 3 offers, 2 of them really sucked, so it didn't really trigger this for us. The third one we like. And we say, okay, this one we like, so we're going to provide this notice. So the seller is now providing written notice to the buyer, and we're going to give them 3 days, and we just saw that written notice saying, hey, we're giving you notice now. And by the way, I recommend that you check all 3 of these. If I'm going to take my house off the market, potentially discouraging other buyers from applying, and I come to you and I say, okay, we have another offer. And if you come back to me and say, okay, we've removed our conditions, you need to remove every condition, and I need to be pretty well guaranteed that you're going to close, or you need to default your earnest money. That's what I want to see as a listing agent, right? That's what I want to see for my sellers. And so if I just checked the due diligence condition or the subject to sell a buyer's property condition, let's say that I just checked this, subject to sell a buyer's property condition. Hey, we've got our home, so I say, hey, we've got another offer. And they come back and say, you know what, fantastic, because this same weekend we were able to close on our home. Now we can proceed. And that week they do their inspection and they come up with an issue that they don't like. And I'm thinking, that's such bull crap, like we had our home off the market for this long and now they're canceling based on this and they still get all their earnest money back. That really sucks. Or they've got the appraisal condition or whatever, right? Whatever reason they make up, I'm going to be very upset that I had another good offer. I notified them I have another good offer, and they said, we're removing our conditions. We're going to proceed. And then they don't. It's very frustrating because I lost a good offer. So for me, I'm going to make this as airtight as I can. I'm checking everything. So they have to remove those conditions. How do they do that? Well, I go back to my notice section and there we go. We got a buyer's notice to seller of removal of conditions. So again, if you're an agent looking to fill these forms out correctly, you read through that in detail. And if it says a notice, well, we need to go find that notice. So addendum number whatever to the REPSI contains the option to keep house on market time clause addendum. This buyer's notice informs seller that buyer removes all of the conditions checked in section 1B. So we have now removed all of our conditions right here. So we're going to proceed forward, right? Now, if I wanted to make this even tougher, in addition to removing the above check conditions, the buyer agrees that they're going to deposit additional earnest money of, maybe I ask for an extra $2,000 or something like that, an extra $10,000. It all depends on the price of the home, size of the home. But they're going to add additional earnest money deposit. And again, if I've checked all of these conditions, then this earnest money is effectively non-refundable. They don't get it back if they do not perform, right? That gives them another 4 calendar days to put that in there. And you could also do nothing. Maybe you like their offer enough. You don't have to put anything here. But if you're really saying, hey, we've got a great offer and we really like the offer, this backup offer that we've got, then if you like if you don't perform, we're going to have some real penalties put in place here. Now, if buyer does not remove from the REPSI the above checked conditions, if they say, hey, we just can't do that within the time specified in section 1B of this addendum, or 3 days, then the REPSI automatically becomes canceled. That means I don't have to send a notice of cancellation. So as a buyer, I have to send this notice to removal of conditions. If I don't do that, it's an automatic cancellation. That is very important to understand, right? Automatically canceled, in which instance the earnest money goes back to the buyer, right? Sorry, I can't remove my conditions. I get my earnest money back. We go our separate ways. Buyer didn't suffer a penalty. Seller, they might have suffered a little bit because they put their home in active TC status, but that's all they get. Okay.
Can I ask a quick question?
Absolutely.
So this is the option to leave the property on the market, which is basically an addendum or a counter to the offer at the time that the buyer is making the offer.
Correct.
And if I'm the buyer's agent, I would not like to see all three of those checked. Obviously, I'm not going to advise my client to forego any due diligence if they haven't had an opportunity at that point. Let's say that they were able to remove the condition to sell their property and pretty quickly, but they still haven't had an opportunity to do all their due diligence, and this is going to just completely eradicate any opportunity for that without them putting themselves at risk.
Yeah, that's a good point. So in the scenario that I gave you where maybe we've got a home to sell, a property to sell, and we're under contract on it already. We're 5 days away from closing. So I have to have my subject to sell a buyer's property addendum. I'm 5 days away from settlement on that. But because I haven't settled on it, we haven't closed on it yet, I don't have that money, I have to use that form. The listing agent counters with me with this, and we're just barely writing an offer, and we're going to close in 5 days. That doesn't give me time to do my due diligence, appraisal, or financing. And that is a point that you may want to negotiate. So again, it's very situational. If I'm very near the end of the process of selling my property, then I would, like Jen said, that's a great point, Jen, I would push back on a seller checking all of these. Like, hey, we do expect to close on this property within the next 5 days. That doesn't give us time to get these things done. If, however, my home has not even hit the market yet, then I don't have a lot of grounds to push back on these things, right? So, yeah, this is part of the negotiating process, and it's a really good conversation to have with your buyers or sellers. Andre, again, you've got your hand up.
Hey,
You muted and then unmuted. Or unmuted and then muted.
okay, can you hear me?
Yes.
So, I would say probably to the answer that you gave initially, if you're representing the buyer, you raise as many objections as you can as soon as you can. Like if you can get them pre-qualified with the lender, that's a guarantee that they will get financing, then you don't have to worry about that being an objection. And the same thing with the due diligence. Like even though your due diligence deadline is way out there, you just get it done so that if this happens, you've already, for your buyer, you've erased all of these objections or concerns that they're now going to buy a house that they haven't done any inspections on, and that puts them very compromised. I mean, what do you think about that, Eric?
I agree with that completely. I think as a buyer, we're trying to show the seller that we have every intent and we're taking every action that we can to move forward with this.
I do have one question real quick.
Yeah.
So, and this is going to sound really, dodgy, but let's say that I have a home listed. The offer that comes in has $1,000 earnest money. It's not really that great of an offer. And then I tell them, well, we want to, and they do have these contingencies. on there. And so we do an active time clause. And then we get an offer in that's like $50,000 more than this offer. What are the options of my listing client? Just return earnest money and going with a different offer. How complicated is that?
That's not an option. What our option is outlined by the contract is to notify them that we have another offer. And again, if I've checked all of these, then they have to remove all of their conditions. And so if they say, okay, we're removing our conditions, then again, this contract is binding on me. So if I want to accept this $50,000 higher offer, and I just say, hey, we're going to cancel on you and give you back your earnest money.
I'm sorry, not give back. I mean, match their, so the damages of the $1,000 is that you would return them $2,000, right?
Right. But we don't get to pick those damages. The aggrieved party is the one that gets to pick the damages. So if the seller defaults because they've received a much higher offer, the buyer is the one that gets to pick the damages. Now, maybe they pick the, hey, we'll get our $1,000 earnest money back in an equivalent amount, another $1,000 on top of it, but maybe they won't. Maybe they'll sue to enforce the contract and make you sell to them. Maybe they will sue for actual damages, which may be significantly more than that. Maybe it's not, but in that case, I think that is one where they could sue to have the contract enforced and have the property sold to them, right?
Okay.
So it is not the person that breaks the contract, that breaches it, they aren't the ones that get to choose the penalty. So if I'm talking to my seller, then what I want to do is I say, hey, we make this as difficult for this buyer to perform as possible because we don't want them to perform. We want them to cancel. We'll give them their earnest money back, and then we'll move on to this other offer that's going to net us $50,000 more money. And so I've had this happen before, and I notify the buyer number one, and buyer number one says, okay, well, we just need this, and they're all reasonable requests. And I say, no. Well, can you give us this? No. And they're like, dude, we're $1,000 away for like, negotiate with me a little bit. And I say, no. And I say, dude, I'll be really upfront with you. I have another offer that's much better than yours. If you don't perform exactly as your contract is written, that's good for us. So you perform exactly, don't ask for anything else. We're not going to give you an extra day on any deadlines. We're not going to give you $1,000 concessions. We're not going to give you anything. If you don't perform, that is good for us. So you perform exactly as the contract, and they never bothered me again, and they closed. Now, that wasn't great for my client, but it's better than my client canceling because I gave them bad advice and then getting tied up in a lawsuit. But it did stop this buyer, which had come back to us multiple times saying, well, we want this, and we want this, and we want this. And finally, I said, no, you don't get anything. We have another offer that's better in backup position. Okay. So what I could do is this second offer, I can accept that in backup position and I can hold on to that. And if this buyer number one does give me problems as they progress, I'm just upfront with them and I say, hey, if you don't perform exactly, that's good for us. So quit asking for stuff, right? You said you would do this. You said you would pay this price. You said that you'd waive these conditions. Quit asking for stuff because you're not going to get it. And that agent wasn't super happy, but they at least knew where they stood and they were able to move ahead and proceed and close with the deal. And we had no issues after that. Rebecca, question.
Yeah, so you just said that if the buyer does not back out, then you accept that other offer in backup. But if you don't know that before you send the the removal, the option, or the
section B.
Yes. So do you recommend on the second offer that say $50,000 more, whatever we're saying, do you recommend accepting that in backup at that time and then taking them out of backup, or does that matter because they can back out anyway? What's your recommended procedure there?
So notice this language right here in 1A. we're notifying the buyer in writing of an accepted backup offer. So that
Okay.
implies that we did put that buyer in backup position, right? So we have accepted them. They are in backup position. Now we notify buyer number one. We've got a backup offer. They're under contract. Well, not under contract, but we've accepted them in backup position. We're notifying you. And so again, as a seller, I'm going to try to have all of these three connected. And if Jen's the buyer's agent and she pushes back and says, hey, we're only 5 days away from settlement, we will need more time for this, I might push back against her again and say, well, we might not get an offer in the next 5 days. If we do get an offer in the next 5 days, then you can remove your subject to sell, right? So there is a buyer's notice to seller of removal of conditions. And so let's say that I push back as the listing agent and I say, well, Jen, this is the way I'm going to proceed. I don't want any risk. If you really do close in the next 5 days, let's say on day 2 of the next 5 days, I get an offer for $50,000 more. And you say, but hey, we still want the home, but we haven't had time to do our due diligence. Well, again, still that's your problem. I've got an offer for $50,000 more. So I think I would still push back as the listing agent and try to have all three of those conditions checked. And now what I'm really looking at is my backup offer really that good that I would force a good buyer that's about to close on their property in 5 days, that I would force them into this really tough position of waiving their due diligence, waiving their finance and appraisal, right? So it causes me to look very closely at the offers that I have. So there isn't a right or wrong answer for every scenario. Every scenario needs to be gauged independently. We just need to make sure that we understand these forms so that we can use them correctly, right? So if I'm the buyer, if I'm, if it's Jen, she's representing her buyer, and within just a couple of days, they get their other property sold, then they can send this notice over to me saying the seller removes all their conditions. And well, this is all the conditions in 1B. It's not just the sale of their property. So there really isn't a notice that says, hey, we've removed everything. It's just, especially if I've checked all of them, they can send a notice saying, hey, we've sold our home, which is the financing, the subject to sell buyer's property condition. There really isn't a notice saying we've only sold our home, but we haven't done these other things. I can give written notice, like an email that says we've sold our home, so we're going to proceed, but it didn't satisfy these other things. So as a seller, if I got another offer, they've sold their home, again, unless it's a really, really good offer, then I'm going to proceed with Jen's offer here. And, they've taken care of this issue. And again, maybe I've negotiated real hardball and they've waived their due diligence as well. But as Andre mentioned earlier, the best thing for my buyers would be, regardless of when my deadlines were pushed out to, I want to move as quickly as possible on these things, because that shows the seller that we are really acting in good faith. We're really trying hard to make this happen. And that makes the seller much more have a tendency to lean towards favoring me. So even if they do get another offer that's $5,000 or $10,000 higher, they've got to say, well, these buyers have really been on the ball. They've done a great job. They've cleared their due diligence. They've cleared everything that they can. And even though we could net $10,000 more, we don't know that this unknown buyer B is going to do all of this. They may do inspections. They may come back and ask for extra money on top of it. They may ask for repairs to be done, which buyer A didn't ask for. And so even though we could get $5,000 or $10,000 more, we're going to go with we're going to stick with buyer A, because they have shown through their efforts that they're really intent on buying this home. Feel more solid about them. Eric, you got a comment?
Yeah, question. Considering that, $50,000 more for this other offer scenario, right? I mean, you could sweeten the deal with them, right? If they're threatening to sue you or do something like that, I mean, you could always sweeten the deal instead of giving them their $1,000 earnest money back. You could give them $10,000 earnest money. As long as it's agreeable between the two of you, you could still get out of it that way as well, correct?
Yeah, and again, if they're threatening to sue you, they can't threaten to sue you unless you actually do it. But you could go back to them and say, "Hey, this is what we've got. We'd like to negotiate as a way to basically buy out your position." So yeah, you can negotiate that later on. Okay. So, anyways, there are a lot of forms. We've got the subject to sell. We've got the option to keep property on time clause. I'm not going to go into this one. I was going to. It's one that is rarely used, and it's related to the subject to sell a buyer's property, but it's the flip side. It's the subject to the seller finding a property. Like, hey, we'll sell our home, but we haven't found another home yet. So we'll accept your offer subject to us finding another home. Of course, so I'm not going to go into that, but these two, of course, reference the purchase contract. There's the notice to the seller that they're removing their conditions. There's a buyer's notice of cancellation. If we look at that form and the buyer chooses to cancel, then one of the ways that they can cancel is they're subject to sell. So if I needed to cancel because I wasn't able to sell my property in time, then again, I'm going to jump down here to number 3, and I'm canceling based on the subject sell a buyer's property addendum. I've done a separate training that goes into detail on the reasons we need to use the cancellation form correctly. We need to make sure that we're checking the correct box to avoid potential legal issues where somebody checks the wrong thing. Maybe they check the financing condition, but what they meant was canceling prior to the financing deadline, but they checked the one that says they're canceling after the financing deadline. Those are not the same thing, right? So we need to make sure we're using the right cancellation. But if the buyer isn't able to perform, then they could do this cancellation here. We've already looked at this one, the seller's notice to buyer of accepted offer. So again, we've got an option to keep house on market. We're notifying you that we have accepted another offer in backup position, and then you have to remove everything or automatically it becomes canceled. And again, there's a seller's notice of cancellation as well. And if we scroll down to this, we don't have a specific cancellation one for this section, so we would have to check other and describe it. And if this one triggered a seller's cancellation. So anyways, I'm going to stop sharing that screen. And here's the bottom line is this form is a very common one to use. There's no reason as a seller that I should shy away from a buyer using this because it's a very common scenario, right? But I just want to make sure that I'm protecting my seller and giving them the opportunity to continue to market their property, giving them the opportunity to accept another offer in backup position. And at the same time, if I'm representing the buyer, then I need to make sure that I have some, I need to know how to kind of sweeten the pot, that I'm going to get my inspections done as quickly as possible, even though I may have, because once we sell this property, it's going to be a cash purchase. We're going to have all the money we need to buy it outright. So I don't have a finance and appraisal deadline, but I still have to put my due diligence deadline out 2 months. I'm going to still get my due diligence done right away, right? I want to operate in a manner that keeps that seller or makes that seller less likely to try to trigger that backup offer because they see somebody that's really worked hard to get this, that didn't raise concerns with their inspections. They're all ready to go. All of those things work in my buyer's favor. So I need to understand the forms. I need to understand the proper counters. I need to understand the notices that are required. Again, if we go back to the real estate purchase contract, to the notice section, they need to be in writing. There's 3 things required for notices. They need to be in writing. They need to be signed by the client, and they need to be received by the other party. And that is different than what's required for acceptance. So we need to understand the difference of those 2 things. And these forms require lots of notices. So we need to know which are the correct notices that we're using. And I usually don't see all of those. Like this isn't used as correctly because I don't think a lot of agents number one, I don't think they understand all the work that the attorneys have done to provide the correct forms for them. And so when they're not doing the correct forms, they're creating flaws in their contracts, which the other party could take advantage of. And so I want you to know that we'll fight for you. But in order for us to fight for you, to fight for your clients, you know, when an agent calls me up and says, hey, this agent is saying something, if I open up the file and the forms aren't used correctly, if we've got a flawed argument, if we didn't use it right, and I know that if we go in front of an attorney, we're going to look at fault, I can't fight for that, right? So you guys give me the opportunity to fight for you. You guys give me very well-written contracts, and we'll have your back all day long, and we'll help your clients, and you'll have raving fans. And quite often the most difficult transactions are the ones that generate the most referrals for you, because your clients have seen you fight for them, right? So these forms give you that opportunity to really shine. And they are copyrighted by the UAR. These are not forms that are available to the public. The public has no idea of how to use these. They don't have access to them without through a real estate agent. There's very few forms that are publicly available on the Division of Real Estate's website. So these are things that you provide value with. And I want you to believe in your own value. So when you're out there selling your services, you know that you are, because you are an agent that takes their business seriously, you can provide lots of solutions for them. That makes you more valuable, right? You're protecting them better. You're helping them navigate this potentially legal minefield, and that creates value. So thank you guys for joining me. Thank you for taking your business seriously. And if you have any other things that you'd like to see trainings on in the future, please feel free to email me directly at brokerericlee@gmail.com.